I'm Angenette Levy, and thanks for joining us here on Law and Crime. Bryan Kohberger, the man accused of murdering 4 University of Idaho students, was back in a Latah County courtroom on Thursday morning. And at that time, his attorney asked that a preliminary hearing be pushed out until the last week of June. They want that hearing to last between 4 and 5 days, or at least they're requesting an entire week so they can question witnesses that the prosecution will put on to show that there is probable cause that Bryan Kohberger is the person who committed these crimes. He's accused of breaking into a house in Moscow, Idaho, in the early morning hours of November 13th and murdering Maddie Mogan, Kaylee Gonsalves, Ethan Chapin, and Xana Kernodle. And joining me to discuss this development in the case is Dave Leroy. He is a former attorney general for the state of Idaho. Dave, welcome here to Law and Crime. Thanks for joining us.
You're welcome. Nice to be with you.
What are your thoughts on Ann Taylor requesting a preliminary hearing and saying, no, we want it not, we're going to waive the speedy, trial rights. We want this pushed out until the last week of June, and we need 4 to 5 days for it?
Well, it certainly was predictable that the matter would be moved out for some period of time, because in complicated cases, defense always here and elsewhere around the country wants to get as much evidence as they can in their hands by way of discovery. And that would be police reports, witness statements, scientific reports, all of the kinds of things that might have some probative value on the question of probable cause, either that the offense was committed or was committed by this defendant. So it's entirely predictable that additional time was asked for. 6 months is probably not unreasonable in this case, given how it's come together with evidence on several different tracks, each of those tracks being susceptible of a different kind of analysis by the defense. So that's not surprising at all. And a date certain in June is a reasonable way to go forward. It gives the public some notice and expectation. It gives the defense the opportunity to explore, and it gives the prosecution, as well, an additional opportunity to pull together its investigative materials and continue to find evidence to the extent that it can. The request for 4 or 5 days is highly theoretical, because it's up to the prosecutor to choose what evidence is put on at that hearing. If they decide that they want to put on 1 day's worth of evidence, then that's probably how long that hearing will last, plus cross-examination. But leaving a large block of time available for possible inquiry by both the defense of all of the prosecution witnesses is certainly a possibility. I should note that at a preliminary hearing in Idaho under our criminal rules, hearsay is permitted as to evidence of scientific tests done by government agencies or state licensed laboratories. So it will not always be necessary to call all of the witnesses that one must have at trial at a preliminary hearing, where certain of those hearsay rules are permitted at a preliminary hearing.
So for instance, if a detective is on the stand testifying, Bill Thompson could hypothetically ask, okay, so you got some DNA results back from the lab about the sheath in this case, and what did those results tell you? And he could answer that question, even though he didn't conduct the testing, he just received the results.
Precisely correct. Not only would he have that test in hand and show it and put it into evidence, but they wouldn't necessarily have to show a chain of evidence back to a laboratory. They wouldn't have to show the credentials of the laboratory expert. They wouldn't have to have that expert testify, et cetera, et cetera. In a sense, and in fact, the laboratory report would speak for itself as to whatever appeared to be the reliable conclusions contained therein.
Mm-hmm. And how many, you said it's up to the prosecutor, obviously. Bill Thompson and the woman assisting him, they will kind of lay out how they are going to do this. And they can call 1 witness, they can call 5 witnesses. It's really up to them.
Precisely. And they could put in the evidence, which we already know about in the affidavit for arrest, and do that through 1 or more officers, 1 or more witnesses. or they could put in additional materials, which they may. But at this point, we have a date certain, but we don't have any certainty about what the prosecutor will show there. We merely know that they will have to meet the test of probable cause to believe that an offense was committed and that this defendant did it.
And I think people need to keep in mind too, the discovery in this case is going to be voluminous. There's so much video evidence, around 20,000 tips. So we're talking terabytes of information. They are going to be given hard drives full of information. Plus, we know that the vehicle was being searched. It was seized during Kohberger's arrest, which happened just about 2 weeks ago. And, there are still lab results coming in, plus any other tips or information they are investigating. So it's going to be a lot. As far as homicide cases go in Idaho, this has got to be the biggest homicide case that the state has seen, at least in recent memory, aside from the Daybell case that's going on in another part of Idaho.
Now, I was going to qualify your comment by a reference to the Daybell case, which another era in Idaho, it seems 2 or 3 years ago now, began with that difficulty. But it's a complicated case, clearly, but it's also a focused case in some sense, in that you've got one crime scene, you've got one defendant, you've got one chain of evidence that links those two. And so in some regards, it's not as complicated as other crimes that have been prosecuted in this case, in this state, but it certainly is one that has captured national attention, has destroyed the feeling of safety in a college community. It has many, many social and cultural and criminal justice applications and implications. It will be up to Idaho, and I think we'll rise to the challenge to provide a fair and objective trial in this case to Mr. Kohberger, who is presumed to be innocent at this time.
And in your experience, do you see this trial happening a couple of years out? Because, we'll have the preliminary hearing and then an arraignment. Obviously, some other things will take place, pretrial motions. There's always the possibility of a plea deal, although Bryan Kohberger is maintaining his innocence here.
Well, the good thing about Idaho is that we can try cases, felony cases, within 6 months, as we're constitutionally required to do here, because we have open courtrooms and juries and judges available to do so. So the pace with which this case will proceed will entirely be related to, first and foremost, the defendant's desire to exercise his right to a swift trial. Secondly, the chemistry between the defense and the prosecution about exploring things, discovery, the delivery of documents, materials. I suspect that the defense will ask either the trial judge or the magistrate for additional investigative authority and additional investigators of this specialty or that, et cetera. So we'll have to see. It could indeed pend over a year or two if we're actually headed to a jury trial. On the other hand, we're ready to try this case in 6 months as constitutionally required, if the defense wishes to do so.
Change of venue, is that something you see happening? Are those, is that used, that tool, moving venue? Does that happen a lot in Idaho?
Well, it doesn't happen a lot, but it certainly is contemplated in character cases of this unique character. Waitau County is a county of 40,000 people. The university has about 11,500 students. This case has riveted those communities like no other in probably the entire history of the University of Idaho, going back to 1889. So to presume that there's someone in Waitau County who hasn't heard about the case, doesn't have opinions one way or another about the case, hasn't perhaps driven by the area of 1122 King Street just to see precisely where it's situated, is a false presumption, I think. But it may be that both the prosecution and the defense ask for a change of venue to one of the more urban counties immediately north or immediately south of Waitau County, or perhaps even here to Boise, where I sit, the capital city, 300 miles away, or even to eastern Idaho, 400 or 500 miles away. All of those are possible, and I think probably likely here, given the circumstances and the dreadful nature of this case.
This is a huge case, a challenge for any prosecutor. What can you tell us about Bill Thompson?
Bill Thompson, with his glorious white Santa Claus beard, is a thoroughly experienced prosecutor. He is, in fact, the most senior elected prosecutor in the state of Idaho. He's been 40 years at the bar, did about 10 years in private practice after he graduated from the University of Idaho. And he has literally for 3 decades been the elected Latah County prosecutor, doing a superb job. He's a well-spoken man, as you can tell from his press encounters. He's a bright fellow, and he has enough experience that he both trains other prosecutors and has acted as a special prosecutor in cases for other counties and conflicts, et cetera. So he's thoroughly up to this task.
Well, Dave Leroy, former Attorney General for the state of Idaho, thanks so much for coming on to offer your insight and your expertise. We appreciate it.
You're welcome, Miss A. Nice to be with you.
You too. I'm Angenette Levy, and you've been watching Law and Crime.